The American Sleep Academy, improving patient care through education.
Welcome to the American Sleep Academy's presentation of Patient Confidentiality and HIPAA Privacy Rule, the Health Insurance Portability and Accountability Act of 1996. HIPAA, which stands for the Health Insurance Portability and Accountability Act of 1996, required the U.S. Department of Health and Human Services to develop a series of rules governing health information. In general, the rules are intended to standardize the communication of electronic health information between healthcare providers and health insurers. In addition, the rules are intended to protect the privacy and security of individually identifiable health information. In this presentation, we will cover covered entities, business associates, protected information, individually identifiable health information, general principle for uses and disclosures, permitted uses and disclosures, authorized uses and disclosures, notice and other individual rights, documentation, common compliance issues, and penalties. Who is a covered entity? A covered entity refers to responsible parties. HIPAA applies to any of the following. A health plan. A health plan is any individual or group plan that provides or pays the cost of medical care. Examples of these would be health insurance companies, HMOs, company health plans, and government programs that pay for health care, such as Medicare, Medicaid, and the military and veterans health care programs. Another covered entity is a healthcare clearinghouse. A healthcare clearinghouse refers to any entity that helps healthcare providers and health plans standardize their health information. A covered entity can include healthcare providers such as doctors, clinics, psychologists, dentists, chiropractors, nursing homes, and pharmacies. These examples will only be covered if they transmit any information in an electronic form. In the next slide, we will show you how to determine if you are a healthcare provider. Is a person, business, or agency a covered healthcare provider? Does the person, business, or agency furnish, bill, or receive payment for healthcare in the normal course of business? If they do, then you will also ask, does the person, business, or agency transmit or send covered transactions electronically? If they do, then the person, business, or agency is a covered healthcare provider. So let's track back. If they do not transmit covered transactions electronically, then the person, business, or agency is not a covered healthcare provider. Now let's track all the way back and ask the question again. Does the person, business, or agency furnish, bill, or receive payment for healthcare in the normal course of business? If they do not, then they are not a covered healthcare provider. Let's move on to business associates. Who is a business associate? A business associate is a person or organization, other than a member of a covered entity's workforce, that performs certain functions or activities on behalf of, or provides certain services to, a covered entity that involves the use or disclosure of individually identifiable health information. Examples of business associate functions or activities on behalf of any covered entities would include claims processing, data analysis, utilization review, billing groups or departments, IT service groups, or contractors, such as scoring technologists. Business associate services to a covered entity are limited to legal, actuarial, accounting, consulting, data aggregation, management, administrative, accreditation, and financial services. Persons or organizations are not considered business associates if their functions or services do not involve the use or disclosure of protected health information, and where any access to protected health information by such persons would be incidental, if at all. A covered entity can be the business associate of another covered entity. When a covered entity uses a contractor or other non-workforce member to perform business associate services or activities, the rule requires that the covered entity includes certain protections for the information in a business associate agreement. In certain circumstances, governmental entities may use alternative means to achieve the same protections. In the business associate contract, a covered entity must impose specified written safeguards on the individually identifiable health information used or disclosed by its business associates. A covered entity may not contractually authorize its business associate to make any use or disclosure of protected health information that would violate the rule. All individually identifiable health information held or transmitted by a covered entity or its business associate in any form or media, whether electronic, paper, or oral, falls under the privacy rule and is protected health information or PHI. What is individually identifiable health information? It is information, including demographic data, that relates to the individual's past, present, or future physical or mental health or condition, the provision of health care to the individual, the past, present, or future payment for the provision of health care to the individual, or anything that identifies the individual or for which there is a reasonable basis to believe it can be used to identify the individual. Some examples of these would be name, address, birthday, and social security number. The major purpose of the privacy rule is to define and limit the circumstances in which an individual's protected health information may be used or disclosed by covered entities. A covered entity may not use or disclose protected health information except either as the privacy rule permits or requires, or as the individual who is the subject of the information or the individual's personal representative authorizes in writing. A covered entity must disclose protected health information in only two situations. The first situation would be to individuals or their personal representatives, specifically when they request access to or an accounting of disclosures of their protected health information. The other instance would be to Health and Human Services when it is undertaking a compliance investigation, a review, or an enforcement action. A covered entity is permitted, but not required, to use and disclose protected health information without an individual's authorization for the following purposes or situations. To the individual: treatment, payment, and healthcare operations. Opportunity to agree or object. Incident to an otherwise permitted use and disclosure. Public interest and benefit activities. Or limited data set for the purposes of research, public health, or healthcare operations. Covered entities may rely on professional ethics and best judgments in deciding which of these permissive uses and disclosures to make. Let's go through these so we can better understand each instance. To the individual: a covered entity may disclose protected health information to the individual who is the subject of the information. Treatment, payment, and healthcare operations. Let's start with treatment. Treatment would be the provision, coordination, or management of healthcare and related services for an individual by one or more healthcare providers, including consultation between providers regarding a patient and referral of a patient by one provider to another. Payment. Payment encompasses activities of a health plan to obtain premiums, determine or fulfill responsibilities for coverage and provision of benefits, and furnish or obtain reimbursement for healthcare delivered to an individual, and activities of a healthcare provider to obtain payment or be reimbursed for the provision of healthcare to an individual. Healthcare operations. Any of the following activities qualify. Quality assessment and improvement activities, including case management and care coordination. Competency assurance activities, including provider or health plan performance evaluation, credentialing, and accreditation. Conducting or arranging for medical reviews, audits, or legal services, including fraud and abuse detection and compliance programs. Specified insurance functions, such as underwriting, risk rating, and reinsuring risk. Business planning, development, management, and administration. And business management and general administrative activities of the entity. Business management includes, but is not limited to, de-identifying protected health information, creating a limited data set, and certain fundraising for the benefit of the covered entity. A covered entity may use and disclose protected health information for its own treatment, payment, and healthcare operations activities. An example of this would be if you, as a sleep lab, used protected health information about an individual to provide healthcare to the individual and consulted with other healthcare providers about the individual's treatment. You would be all right to disclose this information in this instance. In other words, you could give the information to the sleep physician for help and treatment. You may also disclose protected health information about an individual as part of a claim for payment to a health plan. A covered entity also may disclose protected health information for the treatment activities of any healthcare provider, the payment activities of another covered entity and of any healthcare provider, or the healthcare operations of another covered entity involving either quality or competency assurance activities or fraud and abuse detection and compliance activities, if both covered entities have or had a relationship with the individual and the protected health information pertains to the relationship. An example of this would be if you were to get information from the primary care physician for a sleep study. Also, you may send information from a sleep specialist to a primary care physician. You may give patients billing information to emergency personnel if the patient is being transferred for emergency care. Moving on. Opportunity to agree or object. Informal permission may be obtained by asking the individual outright or by circumstances that clearly give the individual the opportunity to agree or object to the use of their private healthcare information. Where the individual is incapacitated, in an emergency situation, or not available, covered entities generally may make such uses and disclosures if, in the exercise of their professional judgment, the use or disclosure is determined to be in the best interest of the individual. It is a common practice in many healthcare facilities, such as hospitals, to maintain a directory of patient contact information. A covered healthcare provider may rely on an individual's informal permission to list in its facility directory the individual's name, general condition, religious affiliation, and location in the provider's facility. The provider may then disclose the individual's condition and location in the facility to anyone asking for the individual by name, and also may disclose religious affiliation to clergy. Members of the clergy are not required to ask for the individual by name when inquiring about patient religious affiliation. A covered entity also may rely on an individual's informal permission to disclose to the individual's family, relatives, or friends, or to other persons whom the individual identifies, protected health information directly relevant to that person's involvement in the individual's care or payment for care. An example of this would be giving out an oximeter device to a family member or getting follow-up information from a spouse. Also, you may give information to the coroner's office after death and to law officials needing CPAP pressures or other such information. A covered entity may rely on an individual's informal permission to use or disclose protected health information for the purpose of notifying, including identifying or locating family members, personal representatives, or others responsible for the individual's care, location, general condition, or death. Protected health information may be disclosed for notification purposes to public or private entities authorized by law or charter to assist in disaster relief efforts. Incidental use or disclosure. The privacy rule does not require that every risk of an incidental use or disclosure of protected health information be eliminated. A use or disclosure of this information that occurs as a result of, or as incident to, an otherwise permitted use or disclosure is permitted as long as the covered entity has adopted reasonable safeguards as required by the privacy rule. and the information being shared is limited to the minimum necessary, as required by the privacy rule. Many healthcare providers and professionals have long made it a practice to ensure reasonable safeguards for individuals' health information. For instance, by speaking quietly when discussing a patient's condition with family members in a waiting room or other public area, by avoiding using patients' names in public hallways and elevators, and posting signs to remind employees to protect patient confidentiality, by isolating or locking file cabinets or record rooms, or by providing additional security, such as passwords on computers maintaining personal information. Protection of patient confidentiality is an important practice for many healthcare and health information management professionals. Covered entities can build upon those codes of conduct to develop the reasonable safeguards required by the privacy rule. Public interest and benefit activities. The privacy rule permits use and disclosure of protected health information without an individual's authorization or permission for 12 national priority purposes. These disclosures are permitted, although not required, by the rule in recognition of the important uses made of health information outside of the healthcare context. Specific conditions or limitations apply to each public interest purpose, striking the balance between the individual privacy interest and the public interest need for this information. The 12 national priority purposes that are allowed are: required by law, public health activities, victims of abuse, neglect, or domestic violence, health oversight activities, judicial and administrative proceedings, law enforcement purposes, decedents, cadaveric organ, eye, or tissue donation, research, serious threat to health or safety, essential government functions, and workers' compensation. Let's go over each one of these. Required by law. Covered entities may use and disclose protected health information without individual authorization as required by law. Public health activities. Covered entities may disclose protected health information to public health authorities authorized by law to collect or receive such information for preventing or controlling disease, injury, or disability, and to public health or other government authorities authorized to receive reports of child abuse and neglect. Entities subject to FDA regulation regarding FDA-regulated products or activities for purposes such as adverse event reporting, tracking of products, product recalls, and post-marketing surveillance. Individuals who may have contracted or been exposed to a communicable disease when notification is authorized by law. And lastly, employers regarding employees when requested by employers for information concerning a work-related illness or injury or workplace-related medical surveillance, because such information is needed by the employer to comply with the Occupational Safety and Health Administration, also known as OSHA, the Mine Safety and Health Administration, MHSA, or similar state law. Victims of abuse, neglect, or domestic violence. In certain circumstances, covered entities may disclose protected health information to appropriate government authorities regarding victims of abuse, neglect, or domestic violence. Health oversight activities. Covered entities may disclose protected health information to health oversight agencies for purposes of legally authorized health oversight activities, such as audits and investigations necessary for oversight of the healthcare system and government benefit programs. Health oversight agency means an agency or authority of the United States, a state, a territory, a political subdivision of a state or territory, or an Indian tribe, or a person or entity acting under a grant of authority from or contract with such public agency, including the employees or agents of such public agency or its contractors, or persons or entities to whom it is granted authority, that is authorized by law to oversee the healthcare system, whether public or private, or government programs in which health information is necessary to determine eligibility or compliance, or to enforce civil rights laws for which health information is relevant. Judicial and administrative proceedings. Covered entities may disclose protected health information in a judicial or administrative proceeding if the request for the information is through an order from a court or administrative tribunal. Such information may also be disclosed in response to a subpoena or other lawful process if certain assurances regarding notice to the individual or a protective order are provided. Law enforcement purposes. Covered entities may disclose protected health information to law enforcement officials for law enforcement purposes under the following 6 circumstances. As required by law. To identify or locate a suspect, fugitive, material witness, or missing person. In response to a law enforcement official's request for information about a victim or suspected victim of a crime. To alert law enforcement of a person's death if the covered entity suspects that criminal activity caused the death. When a covered entity believes that protected health information is evidence of a crime that occurred on its premises, or by a covered healthcare provider in a medical emergency not occurring on its premises, when necessary to inform law enforcement about the commission and nature of a crime, the location of the crime or crime victims, and the perpetrator of the crime. Decedents. Covered entities may disclose protected health information to funeral directors as needed, and to coroners or medical examiners to identify the deceased person, determine the cause of death, and perform other functions authorized by law. Cadaveric organ, eye, or tissue donation. Covered entities may use or disclose protected health information to facilitate the donation and transplantation of cadaveric organs, eyes, and tissue. Research. Covered entities may disclose protected information for any systematic investigation designed to develop or contribute to generalized knowledge. The privacy rule permits a covered entity to use and disclose protected health information for research purposes without an individual's authorization, provided the covered entity obtains either documentation that an alteration or waiver of individual's authorization for the use or disclosure of protected health information about them for research purposes has been approved by an institutional review board or privacy board, or representations from the researcher that the use or disclosure sought is solely for research on the protected health information of decedents, that the protected health information sought is necessary for the research, and at the request of the covered entity, documentation of the death of the individual about whom information is sought. A covered entity also may use or disclose, without an individual's authorization, a limited data set of protected health information for research purposes. Serious threat to health or safety. Covered entities may disclose protected health information that they believe is necessary to prevent or lessen a serious and imminent threat to a person or the public when such disclosure is made to someone they believe can prevent or lessen the threat, including the target of the threat. Covered entities may also disclose to law enforcement if the information is needed to identify or apprehend an escapee or violent criminal. Essential government functions. An authorization is not required to use or disclose protected health information for certain essential government functions. Such functions include assuring proper execution of a military mission, conducting intelligence and national security activities that are authorized by law, providing protective services to the President, making medical suitability determinations for U.S. State Department employees, protecting the health and safety of inmates or employees in a correctional institution, and determining eligibility for or conducting enrollment in certain government benefit programs. For workers' compensation, covered entities may disclose protected health information as authorized by and to comply with workers' compensation laws and other similar programs providing benefits for work-related injuries or illnesses. For limited data set. A limited data set is protected health information from which certain specified direct identifiers of individuals and their relatives, household members, and employers have been removed. A limited data set may be used and disclosed for research, healthcare operations, and public health purposes, provided the recipient enters into a data use agreement promising specified safeguards for the protected health information within the limited data set. Authorization. A covered entity must obtain the individual's written authorization for any use or disclosure of protected health information that is not for treatment, payment, or healthcare operations, or otherwise permitted or required by the privacy rule. A covered entity may not condition treatment, payment, enrollment, or benefits eligibility on an individual granting an authorization, except in limited circumstances. An authorization must be written in specific terms. It may allow use and disclosure of protected health information by the covered entity seeking the authorization or by a third party. Examples of disclosures that would require an individual's authorization would be disclosures to a life insurer for coverage purposes, disclosures to an employer of the results of a pre-employment physical or lab test, or disclosures to a pharmaceutical firm for their own marketing purposes. All authorizations must be in plain language and contain specific information regarding the information to be disclosed or used, the persons disclosing and receiving the information, expiration, right to revoke in writing, and other data. Marketing is any communication about a product or service that encourages recipients to purchase or use the product or service. The privacy rule carves out the following health-related activities from this definition of marketing. Communications to describe health-related products or services or payment for them, provided by or including in a benefit plan of the covered entity making the communication. Communications about participating providers in a provider or health plan network, replacement of or enhancement to a health plan, and health-related products or services available only to a health plan's enrollees that add value to, but are not part of, the benefits plan. Communications for treatment of the individual, or communications for case management or care coordination for the individual or to direct or recommend alternative treatments, therapies, healthcare providers, or care settings to the individual. Marketing is also an arrangement between a covered entity and any other entity whereby the covered entity discloses protected health information in exchange for direct or indirect remuneration for the other entity to communicate about its own products or services, encouraging the use or purchase of those products or services. A covered entity must obtain an authorization to use or disclose protected health information for marketing, except for face-to-face marketing communications between a covered entity and an individual, and for a covered entity's provision of promotional gifts of nominal value. No authorization is needed, however, to make a communication that falls within one of the exceptions to the marketing definition. An authorization for marketing that involves the covered entity's receipt of direct or indirect remuneration from a third party must reveal that fact. The privacy rule requires that the notice contains certain elements. Each covered entity, with certain exceptions, must provide a notice of its privacy practices. It must describe the ways in which the covered entity may use and disclose protected health information. State the covered entity's duties to protect privacy, provide a notice of privacy practices, and abide by the terms of the current notice. Describe individuals' rights, including the right to complain to HHS and to the covered entity if they believe their privacy rights have been violated. Include a point of contact for further information and for making complaints to the covered entity. Covered entities must act in accordance with their notices. The rule also contains specific distribution requirements for direct treatment providers, all other healthcare providers, and health plans. Notice distribution. The privacy rule provides that an individual has a right to adequate notice of how a covered entity may use and disclose protected health information about the individual, as well as his or her rights and the covered entity's obligations with respect to that information. Notices are intended to focus individuals on privacy issues and concerns, and to prompt them to have discussions with their health plans and healthcare providers and exercise their rights. The content of the notice. How the covered entity may use and disclose protected health information about an individual must be in the notice. It also must contain the individual's rights with respect to the information and how the individual may exercise these rights, including how the individual may complain to the covered entity. The covered entity's legal duties with respect to the information, including a statement that the covered entity is required by law to maintain the privacy of PHI, must be included. It also must contain whom individuals can contact for further information about the covered entity's privacy policies. The notice should be written in plain language. The notice must also include an effective date. A covered entity is required to promptly revise and distribute its notice whenever it makes material changes to any of its privacy practices. A covered entity must make its notice available to any person who asks for it. A covered entity must prominently post and make available its notice on any website it maintains that provides information about its customer services or benefits. Direct treatment providers must also provide the notice to the individual no later than the date of first service delivery and, except in an emergency treatment situation, make a good faith effort to obtain the individual's written acknowledgement of receipt of the notice. If an acknowledgement cannot be obtained, the provider must document his or her efforts to obtain the acknowledgement and the reason why it was not obtained. In an emergency treatment situation, provide the notice as soon as it is reasonably practicable to do so after the emergency situation has ended. And make the latest notice available at the provider's office or facility for individuals to request to take with them and post it in a clear and prominent location at the facility. Workforce training and employee sanctions. You should provide privacy training to your entire workforce as necessary and appropriate to your functions. You should develop and apply a system of sanctions for employees who violate the entity's policies or the requirements of the privacy rule. You should designate a privacy official. They are responsible for privacy policies and procedures. You should also designate a contact person or an office responsible for receiving complaints. You must provide a process for individuals to make complaints. You cannot require individuals to waive their rights to file a complaint with the Secretary or their other rights under privacy rule. You should refrain from intimidating or retaliatory acts. Documentation that is required would be policies and procedures, training provided, privacy official, contact person, complaints to covered entity and their disposition, if any, notice of privacy practices, acknowledgement, and good faith efforts to obtain acknowledgements, authorizations, business associate contracts, IRB or privacy board waivers, and designated record sets that are subject to access by the individual, access contact persons, requests, and responses. Documentation requirements must be kept written or electronic for at least 6 years. You are also required to have documentation of amendment contact persons, requests, denials, disagreements, and rebuttals. Information required to be in accounting contact person, requests, and accountings provided to individual. Restriction request agreements. Healthcare claim designations. Affiliated covered entity designations. Certification of group health plan document amendment. Verification documents of public officials, personal representatives, etc. And any other communication required by the rule to be in writing. Next, let's go over the common compliance issues that you should consider. You should determine if you are a covered entity. You should decide on an organizational structure. Identify business associate relationships and enter business associate agreements. You need to develop a valid authorization form for future use. Develop and provide a notice and, if necessary, an acknowledgement form. Develop a system to track and account for disclosures. You should designate a privacy official and contact person or office. You need to design and implement policies and procedures. Develop and implement systems to safeguard PHI. You should train your workforce. And you should check the rule for particular requirements. For investigations and compliance review, the Office of Civil Rights may investigate complaints. They may also conduct compliance reviews to determine whether covered entities are in compliance. To file a complaint. Any person or organization may file a complaint with the Office of Civil Rights by mail or electronically. Complaints should be filed within 180 days of when the complainant knew or should have known that the act or omission occurred. Individuals may also file complaints with the covered entity. Civil monetary penalties can be imposed by the Office of Civil Rights. It is a $100 per violation fine. It is capped at $25,000 for each calendar year for each identical requirement or prohibition that is violated. A covered entity has a right to notice and a hearing before civil monetary penalties become final. You will not receive a civil monetary penalty if the person did not know and, by exercising reasonable diligence, would not have known of the violation, or failure to comply is due to reasonable cause and not willful neglect, and the entity corrects within a 30-day cure period, or the offense is punishable by criminal sanction. Criminal penalties for wrongful disclosures. For knowingly obtaining or disclosing identifiable health information relating to an individual in violation of the rule, there can be up to $50,000 and a 1-year imprisonment penalty. If the offense is done under false pretenses, the penalty can be up to $100,000 and 5 years imprisonment. If the intent to sell, transfer, or use for commercial advantage, personal gain, or malicious harm was a part of the offense, you could receive up to $250,000 and 10 years imprisonment for the penalty. These penalties are enforced by the Department of Justice. Your contact for all of the information contained in this presentation is the Office of Civil Rights. The privacy toll-free number is 1-866-627-7748. Please note the references used for this course. This will conclude the American Sleep Academy's presentation of Patient Confidentiality and HIPAA Privacy Rule, the Health Insurance Portability and Accountability Act of 1996.
The American Sleep Academy, improving patient care through education.